Court calls the case of the people versus Samuel People.
Caitlin Kirby on behalf of the people.
Assistant Public Defender Costin Lubesi on behalf of Samuel Peoples, Your Honor. Mr. Peoples, could you please unmute and state your full name?
Hi, Samuel Peoples.
Thank you. What are we doing?
Right out of the gate, this hearing already feels messy, and that's usually a warning sign in court. You've got the judge trying to figure out where the defendant stands, a public defender saying communication has basically broken down, and now Samuel Peoples himself sounds completely confused about why he's even here. That line, "What are we doing?" isn't just awkward, it tells you this case has already drifted into procedural chaos. And in courtroom situations, confusion can become dangerous fast because judges care about one thing above all else: whether defendants are staying compliant and reachable. Now, to be fair, this situation quickly takes a dramatic turn when Samuel's mother jumps in and reveals he was hit by a car while skateboarding and spent weeks in the ICU. That changes the emotional temperature immediately. Suddenly, this isn't just about missed calls and scheduling problems anymore. It becomes a question of whether the court system and the defense office are actually communicating effectively with somebody dealing with a major medical crisis. But here's the tension. The judge still expects order, structure, and direct communication from the defendant himself. And that clash between family emotion and courtroom procedure is exactly where these hearings start spiraling. Watch closely, because Judge Simpson is already showing signs that he's losing patience with the interruptions, and once a judge feels the courtroom slipping out of control, the tone can change instantly.
Yes, similarly, Your Honor, we would request a short adjournment. I was not able to get in contact with Mr. Peoples. I need him to call our office and update his contact information. Previously, I believe a hideout plea was discussed, so I do need some time to discuss that with him and see if that's...
May 3rd, 2023, 9 a.m. Mr. Peoples, do you have the public defender's office number?
You've called it. Tell them you've already called it, Sam.
No, I don't think I have.
So I'm his mom. Currently,
Yes.
Sam is in a rehab because hit by a car on a skateboard and was in the ICU for 3 weeks. I've spoken to the defender's office. Samuel has called and left voicemails. And I have also spoken to the prosecutor side, and there's several notes within the chart from Christine Endler.
You have the phone number, though.
That, yes, we have it. and you
Okay,
have it. You've
okay,
called
ma'am,
several times.
ma'am. Here's what we're gonna do. Call the public defender's office, make sure they have the correct number. And if you don't want to do it, ma'am, I'll talk directly to him. So don't shake your head when I'm talking to you.
He has
Call
called
them. I'll wait till you're done.
Okay, I have called directly. I have been present when my son called directly. I have my son's phone. He has text directly, and no one has responded to him.
I wanted to ask to verify the phone number, but I called the phone number repeatedly yesterday, the phone number that our office has on file, and I didn't receive any answer.
Right, he is in a rehab right now. This entire case, he went through probation
Can
already
I just
for 6
get
months.
you to do one thing for me? Ma'am, I realize that's your son. He has attorneys. So if I can just get you to do one thing, and that is just please call the public defender's office, make sure that the information that they have to contact you and your son is correct.
This is one of those moments where you can actually see Judge Simpson trying to regain control of the hearing in real time. The issue here isn't whether Samuel's mother cares. Clearly she does. The issue is that courtrooms operate on structure, and the judge is drawing a hard line between emotional advocacy and legal procedure. He keeps redirecting the conversation back to one simple point: verify the contact information and let the attorneys handle the case. And honestly, you can hear the frustration building on both sides. The mother insists they've been calling repeatedly, leaving voicemails, sending texts, basically saying, "We've done our part." Meanwhile, the defense office is saying they couldn't reach Samuel through the number they had. That kind of communication breakdown becomes a nightmare in criminal cases because missed contact can delay plea discussions, court appearances, and potentially favorable deals. Notice the mention of a possible hide-up plea on the table, a potentially major opportunity for the defendant. The judge is basically warning them that continuing this public argument isn't helping Samuel's position at all. What also stands out is how quickly Judge Simpson shuts down the possibility of putting personal information on the record. The second phone numbers start coming up, he immediately says, "We're on YouTube." That tells you he's fully aware these proceedings are public entertainment now as much as legal proceedings. And that awareness changes how modern judges manage their courtrooms. Quick question for you guys. Do you think Samuel's family was genuinely being ignored by the system, or do you think this became a case of too many people talking at once and making the situation worse?
So that they can discuss it. My understanding is there may be a hide-up plea on the table, which is greatly beneficial to your son. So you sitting here talking to me isn't going to do you much good until we can get this resolved.
Well, which number do you have for Samuel? Why don't you ask Sam what number you have?
No, we're not going to put the number out. We're on YouTube, ma'am. I don't want it broadcast to the world unless you want everybody calling.
Well, honestly,
that's why we do it this way.
Sam has the defender's office number and he's called multiple times.
Okay.
I'm just,
ma'am, I don't know you know what? Here's what we're going to do. Mr. Belpesi, guess what? You're the lucky one today. You get a breakout room because I'm done with this one. I'm going to put you into a breakout room. That way you can communicate whatever you need to communicate without mom putting all his business out in the street.
Thank you, Your Honor. I appreciate it.
Put him into a breakout room. May 3rd.
Operating.
May 3rd.
Sam Bernstein for Mr. Johnson, Your Honor. Here.
Yeah.
What's going on, man?
Not much. You look good in orange.
No,
all right.
no. Oh, yeah. So we're asking the court to please set this for a preliminary exam, Your Honor.
We have all discovery shared with the exception of the 911 call that was requested earlier this week. It should be over to Mr. Bernstein by the latest on Monday. My expectation would be more likely that it gets to him tomorrow. Then the court, I would like to address bond.
Why don't you go ahead and address bond?
Now the energy completely shifts because we're moving from a chaotic communication issue into a much more serious bond and victim contact situation. And this is where courtroom hearings can turn dangerous for defendants very quickly. The prosecutor is about to lay out allegations that don't just involve missing court dates. They involve repeated contact with an alleged victim while the defendant is in custody. Judges take that extremely seriously because bond conditions are not suggestions, they are court orders. What's important here is the timing and pattern the prosecutor is establishing. She's walking the judge through the entire chain: arrest, release, adjournment, failure to appear, bench warrant, rearrest, and then over 100 calls allegedly made to the victim's number. That kind of sequence creates a narrative prosecutors love because it paints the defendant as someone who ignores court authority repeatedly. Even before the defense responds, the judge is already hearing words like failure to appear, bench warrant, and 105 calls. Those phrases stack up psychologically in a courtroom. And notice something else. The prosecutor isn't just asking for stricter conditions. She's actively requesting the bond be increased and privileges removed. That means the prosecution believes the current restrictions aren't enough to control the situation. This next exchange is about to become incredibly important because the defendant is going to try explaining those calls himself. And sometimes defendants help themselves in court, but sometimes they accidentally make things much, much worse.
So I understand in this case, bond is currently set at 10,000, cash or surety with no 10% privilege. We did request 150,000 on this case originally. I understand he has his bond currently denied out of the circuit court, and multiple holds in this case. I am actually requesting that bond be raised today, as well as his phone privileges be revoked. I am concerned because the way that I see this playing out is that he was taken into custody for this event that occurred back on May 2nd. After he was taken into custody, he was in custody for a period of time, then was released. Before he was released, we had stipulated to adjourn this case to May 23rd. On that date, he failed to appear in a bench warrant was issued. He was then picked up and arraigned on the bench warrant on July 9th and given the $10,000 cash surety without 10% privilege. In the time that he was in custody before he was released and since he has been picked up, he has called the victim 105 times at her personal number, as well as called the family line 110 times, where the victim answers that phone among other people a period or a number of times. I don't know what contact he had with the victim while he was out of custody, but given his failure to appear previously, as well as the extensive violations in the form of calling the victim, I would be asking for him to be increasing his phone bill to be revoked today.
Your Honor, as far as the phone calls go, Mr. Johnson states adamantly that he's not called Miss Vesey. He says that it was another woman that he's been calling, and that he has not had any contact with Miss Vesey since he's been in jail by phone, Your Honor.
I apologize. It is the victim's phone number because the victim has called our office and provided that phone number that he has called 105 times as her point of contact to our office.
And here we go. The hearing officially turns into a credibility battle. The prosecution just made a very direct factual assertion. The number receiving all those jail calls belongs to the victim. But almost instantly, somebody in the background blurts out, "It's Mom. That's my number." Then the defendant jumps in saying he's actually calling a completely different girlfriend. This is exactly the kind of courtroom moment where things become unpredictable, because now everyone is talking over each other while the judge tries to figure out who's telling the truth. What makes this so dramatic is that the defendant doesn't stay quiet. Instead, he volunteers a huge amount of personal information trying to explain the situation. He says he has 2 girlfriends, claims they all knew each other, mentions a 3-way relationship, and insists the calls were to another woman named Jaleesa, not the victim. The problem is, every extra detail creates more complications instead of simplifying things. Judges generally don't love long, unscripted explanations during bond discussions because they can start sounding defensive or chaotic. At the same time, the defense attorney is trying to narrow the issue legally. He's essentially saying, we still don't know the substance of the calls. That's actually an important distinction because repeated calls alone don't automatically prove witness intimidation or direct violation if the recipient identity is genuinely disputed. But perception matters in court. And from Judge Simpson's perspective, the simple reality is this. The same number tied to the victim allegedly received over 100 calls from jail. That alone is enough to create serious concern while the facts get sorted out.
That's Mama. That's not her number. I call my other girlfriend. That's Mama.
He says he's calling his other girlfriend, Your Honor. I'm sure Ms. Barroso will get me the phone calls. I'll listen to him ASAP. If there's something different, then I'll know within like a day or two. I know what Miss Vesey sounds like on the phone, so I'll be able to tell whether it's her or not.
Your Honor, I'll say something, Your Honor. Usually doesn't work well, but go ahead. I know. Yeah, the number that I've been calling, I got 2 girlfriends. One is Mrs. Vesey and the other is Jaleesa. I called Jaleesa off of my phone number. It's an 858 number. It's registered to my name. It's in my name. Miss Vesey's phone number, I do not call at all. And when I was coming out here, I seen Miss Vesey in the back. Miss Vesey can attest to you. I haven't called her or I haven't called her. I know the contact order, so I know I ain't supposed to have no contact with Mrs. Vesey at all. So I called my other girlfriend, which is Jaleesa. And then once you hear the phone, once you get the phone records, the 100 and whatever times, I'm not too for sure how many times I called her, but once you get the phone records and you hear the phone records, you'll clearly hear that it's not Mrs. Vesey, it's Miss Jaleesa that I am talking to on the phone. Now, if you can hear the records as well, you hear me on that phone call, those same phone calls, telling Jaleesa that I cannot have no contact with Mrs. Vesey And for her, I can't have no third party contact as well with Mrs. VC. So once y'all able to get the contact or the phone records or whatever to my attorney in this court, y'all can listen to them and make the determination. But I don't call Mrs. VC, and Mrs. VC is in the.
All right. Well, let me ask you this then, since you decided to volunteer this. As between your two girlfriends, would there be any reason they would share a number?
No, there's no reason that they would share. No.
So why would the prosecutor indicate that the number that the victim in this case gives them to contact her is the same number that you're calling from the jail?
This exchange is fascinating because you can actually hear the defendant trying to logic his way out of the situation in real time. Samuel's argument is basically this. If the women are different people with different relationships to him, why would the victim's contact number allegedly match the number he's been calling from? Jail? The issue is, even though he sounds calm and conversational, he's walking directly into a dangerous area because every answer creates another question. Then comes the moment that changes the entire tone of the hearing. He casually admits the women know each other because they were in a three-way relationship, and then drops the bombshell that both women are pregnant at the same time. You can almost feel the courtroom energy shift. Suddenly, this isn't just a technical bond issue anymore. It becomes emotionally explosive and chaotic. And while the courtroom may react to the drama of that revelation, Judge Simpson is staying focused on one thing only: whether bond conditions were violated. The defense attorney tries stepping in again to redirect attention toward evidence rather than assumptions, and legally that's smart. He keeps emphasizing that nobody has actually reviewed the audio content yet. But here's the reality defendants often don't realize. Judges can impose temporary restrictions first and sort out details later if they believe there's even a credible risk. That's especially true in cases involving alleged victim contact. So even though Samuel thinks he's clarifying the misunderstanding, the judge may already be leaning toward immediate action just to protect the integrity of the case.
Now that I don't know. I don't know why she would indicate that or what even would give the indications that I'm talking to Mrs. VC, but Mrs. VC was right there.
Okay, do these two women know each other?
Yeah, they know each other for sure. I mean, like I said, we was in a three-way relationship. So like they know each other for sure.
Okay.
And Mrs. VC right there, if you would like to call her up here.
No.
Or she can attest it. I can't talk to her. I got both of them pregnant at the same. You know what I'm saying? So like,
to be fair to James, Your Honor, what we're not hearing is anything about the substance of those calls, whether he's talking about court or proceedings or anything directly related to Miss VC.
The same time?
Yeah.
Okay. All right.
Yeah.
Go ahead. No. My bad. Yeah. I'm sorry, Mr. Bernstein. I didn't mean to interrupt.
I was just saying, Judge, what we're not hearing is the substance of those calls that relate specifically to Miss VC. Anything that would indicate that it is Miss VC herself. We're talking about the number, but as far as like what's on those calls, I mean, what we're not hearing does kind of support what James is saying, that he wasn't calling Miss VC, Your Honor.
Okay. So there's no way without me seeing, I mean, you haven't seen them, Mr. Bernstein, that we're going to know. But my posture on those cases is that if the people are representing to me that the number is the same, I don't know what's going on. Doesn't matter to me. All I know is that the number is the same. I'm not sure what those conversations are. Mr. Bernstein will listen to it, but this time I'm going to revoke your phone privileges.
And there it is, the hammer drops. Judge Simpson has officially decided that, until someone reviews those jail calls carefully, Samuel loses his phone privileges. This is a huge moment because the judge is basically saying, I don't know exactly what happened yet, but I'm not willing to take the risk. That's an important thing viewers need to understand about bond conditions and jail restrictions. Judges are allowed to make preventative decisions before every factual dispute is fully resolved. What actually makes Judge Simpson's ruling interesting is that he leaves the door open for reconsideration. He specifically tells the defense attorney that if the calls turn out to support Samuel's version of events, he'll entertain restoring the privileges later. That's the judge balancing caution with fairness. He's not declaring Samuel guilty of violating the bond outright. He's freezing the situation until the evidence gets reviewed. But emotionally, you can hear Samuel realizing how serious this has become when he asks whether the restriction applies only to that number or to all his family contacts. That question matters because jail phones access is often one of the only connections inmates have to family, children, or support systems. Still, Judge Simpson keeps returning to the same point. Right now, from the court's perspective, there's enough uncertainty and enough concern to justify immediate restrictions. And honestly, this is a classic example of how quickly a defendant's attempt to explain everything can spiral into harsher temporary consequences.
And certainly, Mr. Bernstein, after you hear the calls, if the court needs to reconsider that, I will entertain that and potentially restore his phone privileges. Okay.
That being is when you revoke my phone privilege, is it to that number or is it to all my family?
I'm sorry?
Because I call my grandmother, my other kids, mothers, and all that. So is it revoking that number?
I get you. I'm just saying that what I'm hearing right now is that you violated a condition of your bond. You're telling me you haven't. I've got this phone number. Your counsel hasn't heard it. So what I'm saying is I am, as an initial position, going to revoke your phone privileges. He'll get the phone messages. He'll be able to get to you. They can get to me. I'm not saying I might not restore them, but at this point, this is what I'm going to do. Okay?
All right.
I'll get on it fast.
See, because I need to talk.
So his phone privileges at this time are revoked. With reference to the bond amount, when is the other hearing on?
It shouldn't.
So, and that's the case that bond's been denied.
Yes.
So, okay.
He's not going anywhere anyway.
Well,
So
I know. I get that. That was going to be my point. I just wanted to check the dates. And so I'm just going to continue his bond as it's currently sat until we can get to the bottom of it, because he's going to have a preliminary examination before that other case comes up. I'll set preliminary examination in person. Thank you.
Thank you, Your Honor.
Same time.
Court does call the case, the people of Pittsfield Township versus Aaron Brown.
Silvana Reed, Assistant Public Defender, with and on behalf of Mr. Brown. Mr. Brown, could you please unmute and state your name for the record?
Aaron Brown.
Thank you. Your Honor, we have reviewed probation's recommendation. It is for jail time, and so obviously this is not something that Mr. Brown is looking forward to, but he does understand that is most certainly what the court will order. We would just like to ask, if possible, for him to be allowed to turn himself in on Friday, as he has a bit of time to serve in custody and would like to be able to get his affairs in order.
Now we transition into an entirely different kind of courtroom tension, and this one is about attitude, compliance, and whether a defendant understands who actually controls sentencing decisions. Aaron Brown's attorney is trying to make a fairly standard request here, a delayed surrender date so Brown can get his affairs in order before serving jail time. Courts sometimes allow that, especially when defendants have family responsibilities or stable ties to the community. But the second Brown starts speaking for himself, you can hear the situation begin slipping sideways. Instead of simply requesting mercy respectfully, he immediately frames it like a negotiation. Prom is next month. He's been around for his daughter's life, and he flat out says, "I'm not coming there." Friday. That sentence is incredibly risky to say directly to a judge moments before sentencing is finalized. Judges generally want to hear accountability and willingness to comply, not resistance. And this is where Judge Simpson's courtroom style becomes very clear. He's not reacting emotionally, he's reacting structurally. He starts listing the violations, refusing screenings, refusing assessments, tether violations. In other words, the judge is building a record showing this isn't one isolated issue, it's a pattern. That's critical because once a judge views behavior as a repeated refusal to comply, leniency disappears fast. Watch what happens next, because the conversation is about to shift from a possible accommodation to a direct power struggle over who decides how this sentence gets carried out.
Is there anything you want to say?
I got prom next month. I've been here 17 years. I'll turn myself in after that. I'm not coming there Friday. I ain't missed a beat with my daughter. I've been here the whole 17 years. I can't turn myself in Friday. I don't want to go against your orders. I wish it could be another way. I'm not running from you. I had this thing on when I come to you. I turn myself in, but it will not be Friday.
Well, tell you what, you can elect to do it your way, or you can elect to do it my way. That's going to be your choice. You decide you don't want to do an alcohol screening and assessment. You don't want to do anything. You continue to violate on the scram tether. So here's what we're going to do. It's a sentence of the court. I'll just order the $125 statutory fees. I will order 93 days in the, well, hold on a second. Is that the max on this? Yeah. I'll order 93 days. Well, hold on a second. What did he plead to? Operating one. Okay. I'll order 93 days, Washington County Jail, credit to defendant to serve the balance. Defendant has told me he doesn't want to report, so we're going to do it this way.
I didn't tell
You
you.
report. I'm going to order that you don't get to choose your time.
I mean, can we work?
I'm going to order that you report to the Washington County Jail by 6 p.m. today. Failure to report there'll be a bench warrant issued for your arrest. That bench warrant will issue with no bond. So you don't report 6 p.m. today, your choice. I'll send people to get you. It's real easy for me.
And that is the final line in the sand from Judge Simpson. Aaron Brown tried framing this as a scheduling issue, wanting more time before reporting to jail, but the judge interpreted it as outright refusal to comply with court authority. Once that happened, the entire tone changed from negotiation to enforcement. Judge Simpson makes it crystal clear, report by 6 p.m. today or law enforcement will come get you, and the warrant will carry no bond. That means if Brown ignores the order, he loses control over how this situation unfolds completely. What really stands out in this case is how both hearings revolved around the exact same underlying theme: compliance. In Samuel Peoples' situation, the court was focused on communication failures, bond conditions, and alleged contact violations. In Aaron Brown's case, the issue became whether he would follow direct court orders without trying to dictate his own timeline. Judges can be flexible on many things, but once they believe someone is challenging the authority of the court itself, consequences escalate quickly. Judge Simpson consistently approached both defendants the same way. Explain the expectations clearly, give opportunities to cooperate, and then impose restrictions the moment compliance becomes questionable. Whether it was revoking phone privileges or threatening a no-bond warrant, every ruling came back to courtroom control and accountability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.